So, welcome everyone to today's webinar, Renting Reality, Busting Legal Myths About Landlords and Tenants. I'm Judy, and I'm a staff lawyer here at the Centre for Public Legal Education Alberta, or CPLEA for short. We also have Jessica, artist and designer from our team in the background. She will be putting up links in the chat and also highlighting visual exhibits throughout the webinar. For those who are not familiar with us, well, CPLEA is a nonprofit organization serving all of Alberta, and our goal is to make the law understandable for Albertans. We provide legal information and education through our various booklets, tip sheets, videos, webinars, websites, and more. And before we start, we want to thank our funders, the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation for making initiatives like this possible today. We also respectfully acknowledge that we are located across Treaty 4, 6, 7, 8, and 10 territories and respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada whose presence continues to enrich our communities. So a little bit of a disclaimer here. This webinar today contains legal information only and not legal advice. And of course, sprinkles of pop culture. So viewer discretion is advised. So at CPLEA, we see the same tenancy legal myths come up again and again. So whether online, through questions from the public, or even with legal intermediaries that we work with. So here with me today, I have Tim Patterson, senior staff lawyer from the Edmonton Community Legal Centre, or ECLC, to debunk the hot button tenancy myths that we frequently hear about. And more about Tim here. So after graduating from the University of Alberta Law School, Tim worked in private practice in the litigation department of a large law firm for several years before changing course and joining ECLC, where he has practiced for more than 17 years. In his position of senior staff lawyer, he supports the work of 8 other staff lawyers at ECLC, and supervises articling, summer, and clinical students, and continues to practice in the civil law area, helping clients who would not otherwise be able to get legal assistance with landlord-tenant, employment, debt, human rights, and a host of other issues. Fun fact here, so Tim has supported us from the start with our leap into the digital world of online training when we launched our CPLEA YouTube channel a few years ago. And since then, webinars featuring Tim have been viewed over 885 times now. So Tim, that's a view almost every 1.5 days. And we're very grateful to have you join us again today. And so let's get started with ECLC's new ATLAC program. Can you briefly explain the program for everyone who's here today watching?
Sure, thanks, Judy, and I'm very pleased to be here. So ATLAC is the Alberta Tenant Legal Advice Clinic, which is ECLC's new program. I say new, we're coming up to a year of having run this program. It's really a continuation of the work that we've been doing for years in the residential tenancy space, where we've been providing advice and sometimes representation to people in the low-income area, primarily tenants. The ATLAC program is a continuation of that. We just have a few more resources. So we have 2 additional staff lawyers that do summary clinic advice meetings with clients to provide that advice. And we're not just limited to Edmonton and Northern Alberta anymore. Anyone from across the province can contact ATLAC and receive advice.
Okay, thank you so much, Tim, for the overview for ATLAC. So let's get started here with myths about legislation first. So first myth here, laws about renting are the same across Canada.
So no, that is not the case. Each province and territory, I think, have their own set of rules and regulations about residential tenancies. It is something that falls in the jurisdiction of the provinces. By and large, there's a lot of similarity across the country, but there are really important differences. And so it is important that if you are looking up information, say online, that you know where that information is coming from and to which jurisdictions it applies. So if you're looking at information about Ontario, that won't necessarily be the correct information for Alberta. Like I said, there's a lot of similarities, but there are some differences. For example, in some jurisdictions, their are rent controls so that there's a limit on the amount that rent can be increased. That's not the case in Alberta. There are some other limits on raising of rent, which we'll, I think, get into a little bit later in Alberta, but there isn't an upper limit on the amount in Alberta. There's no rent control. So that's just one example, but there are important differences across the country.
Okay, all right then. How about this next one here? Alberta's Residential Tenancies Act covers most landlord and tenant situations and issues.
Uh, it does cover most residential landlord and tenant situations. It does not cover commercial leases. So if you're renting a space for your business under a commercial lease and you're not living in the premises, then the Residential Tenancies Act does not apply to that. And there are some other exceptions that are built into the Residential Tenancies Act where the Act does not apply. And probably the most common and important one is it does not apply to a situation where you are renting a room in your landlord's house. So if you're sharing living space with your landlord, you're sharing, kitchen, living room, laundry areas, then that may be a situation where the Residential Tenancies Act does not apply. So that means it's going to be whatever agreement that you've entered into with that landlord, and that doesn't, you won't necessarily have the protections of the Residential Tenancies Act if you're a tenant in that situation. There are some other exceptions too, like if you're in a hotel or motel, unless you've lived there for 6 months, then the Residential Tenancy Act might apply in that situation, and some other ones as well. But those are probably the most common exceptions.
Yeah, that's a really good point to make, Tim. And just for the audience to know, we actually do have some resources at CPLEA talking about shared accommodation. So if you're sharing living space with your landlord, there's resources that are available to help you figure out some of the issues that may be involved with that. So moving on here, let's talk about myths while looking for a place to rent here, Tim. So this is a scenario that we often hear about. Where a rental property listing appears to look very nice, okay? But the landlord may be using images from years ago. Sometimes we've even heard of even over a decade ago. So like really outdated looking furniture. And the reality is that the images don't show normal wear and tear and the actual condition of the rental property. And you're also starting to see, a little bit of this being complicated more in the housing industry as well, where there's property listings with images that are touched up with digital tools or even AI enhanced. Like I've seen some of those as well. And it turns out that the property is not what it seems in real life. So some folks think that there's nothing you can do in situations like this. So my question is there any recourse for misleading advertising or representations about conditions of, say, a rental suite or even costs or amenities involved?
So I'm going to give the lawyerly answer here, which is always it depends. But there are things that a tenant can do in that situation. So if there are things that were promised, like amenities or appliances or things like that, that are not included when you actually get to the place, then there are remedies that are available to a tenant in that case, which could include ending the lease, not necessarily in every situation, but that is a possibility. More likely, you might be able to apply for something called rent abatement, which is return of rent already paid because you didn't get what you bargained for. And so there is a process to make an application to the court or to the tenant tribunal, which is the Residential Tenancy Dispute Resolution Service, or RTDRS. So there are some remedies that a tenant can apply for in that situation. That being said, it is really important for tenants to, as much as it is possible, to do their homework before signing a lease. So if you have the opportunity to view the premises before you sign the lease, then I highly recommend that you do that. I know that in some cases that's not possible, like if you're traveling from a different city and you just don't have the opportunity to view it. So it's really important to ask as many questions as you can. But if it's really important that, there's a working stove, for example, it's important that that is included in your lease. Now, that's probably not a great example because in most tenancies, there should be a working stove and it might fall below minimum housing standards if it doesn't. But, if there are things that are really important for you to have in a lease, try to get those put into a written lease if you can.
Okay, yeah, that makes a lot of sense, and especially the point about trying to, if you can, view a property beforehand and not just go by images or what's in a property listing. So just let's roll out an exhibit here to illustrate my point, Jessica, about how misleading images can be now. So what do you think? Which interior is real versus AI generated? Yeah. Well, the first one's actually a real interior. The second one is actually AI generated. So looks pretty good, right? So anyhow, moving on here. So next myth. During a rental application or screening process, the landlord can ask the tenant for personal information, for example, social insurance number, family status, and also collect other personal information through internet searches and also social media.
Yeah, so interestingly, there's nothing in the Residential Tenancies Act itself about this particular issue. However, the Office of the Information and Privacy Commissioner of Alberta has made some rulings and put out some information about this. And landlords are covered under legislation called the Personal Information Protection Act, I believe, or PIPA. So there are limits on the amount and type of information that a landlord can collect. There's not like set rules about specific types of things. Really, what it comes down to is that the landlord is allowed to collect personal information that's relevant to, for example, making a decision about whether to rent that place to somebody, or to have an emergency contact or things like that. If they can show that it's reasonably related to the tenancy itself, then they're likely allowed to collect that information. And there are rules about how they treat that information and who they share it with and how they store it and things like that. But if it's beyond that, if it's not related to the particular tenancy or there's no reasonable tenancy reason to collect that information, then they're not supposed to. And so the Office of the Commissioner did put out some information about, for example, social insurance numbers, and they've taken the position that generally landlords don't need to collect that information. There's no real reason for it. Sometimes the excuse is that, well, we might need it to do a credit check or something on the tenant to make sure that they're able to pay the rent. But you actually don't need the social insurance number for that. And so there's not really a good reason for the landlord to be collecting that information. And the commissioner has made a ruling and put out some information on that.
Yeah, for sure. And we'll pop that up a little bit later in the chat here with the link to the privacy commissioner. But they have some excellent resources as they relate to privacy issues in the tenancy law space. So that's great, Tim. Let's move on here. So what do you think about the myth that lease or rental agreement does not have to be in writing?
So that actually is correct. A lease does not have to be in writing in order to be enforceable. It's a really good idea to have your lease in writing, because if it's not, then there's lots of ambiguity and you don't have the assurance of particular protections. We were talking earlier about making sure that if something's really important for you to have in your tenancy, that you make sure that it's in your lease, because if it's not, then there may be no enforceable way to require it to be there. But the reality, though, is that a lease does not have to be in writing to be enforceable. If you move into a place and just have a verbal agreement with the landlord to say, I'm going to pay you this amount of money per month, and I want to be able to rent this space, that's enough to create a lease. And you will get the protections in the Residential Tenancies Act if that's the case. So there is some content, basic content to that lease that the Act kind of creates because it imposes those particular protections on every single lease. But it's really basic. So it is always best to have a written agreement. Because if there's a dispute, then it becomes a question of your word against the landlords, and there's no guarantee at the end of the day that you're going to be able to convince a decision maker that the situation is as you thought it was.
Yeah, of course. And if it is in writing, I'd have to add, make sure to read your lease, and make sure you know what you're actually getting into. Otherwise, you might end up in a situation like the following meme, as Jessica will pull up right now. This is from the Crisis of Online Contracts, as told in 10 memes, the University of Notre Dame's Journal on Emerging Technologies blog. So there you go. You might not want to be in this situation. Okay, next one here. Landlords can charge tenants for all sorts of things, utilities, security deposits, all sorts of fees, like parking fees, late payment of rent fees, lease break fees. So what do you think about that, Tim?
So the lawyerly answer again is it depends. So a landlord can sometimes charge for all of those fees, but the tenant has to have agreed to those things. And so those type of charges should be in the lease. And if they're not, what can happen then is any changes that the landlord, increases that the landlord tries to impose might be considered a rent increase. And there are rules about when, how often, and what type of notice is required if there is a rent increase. And so while a landlord can put charges, attach charges to a tenancy, there has to be an agreement. And in the absence of an agreement, it might be considered to be a rent increase. There are things that can be outside of the lease agreement as well. So for example, if you are responsible for paying for your own utilities and you have like your own metered property where the utilities are measured and you are charged for that property, then that is outside of the lease. And so of course that amount can go up and down depending on usage. But if utilities are included in your lease, then if the landlord tries to increase them, they are subject to the rules in most cases relating to rent increases.
Okay, that's good. Let's talk more about myths now when a tenant is already renting a place. So we're switching gears here, they're already renting a place. What are some of the myths that might come up? So you've already mentioned this a little bit earlier, Tim, about raising rent. So this next statement here, a landlord can raise rent whenever they want and in whatever amount that they want.
So yeah, that is not true. As I said, there are rules around when and how often and what notice is required if there is going to be a rent increase. The first thing I'll say is that it partly depends on what kind of lease you have as well. So if you are in a fixed term lease, so that is you're in a lease that says this lease is to start on this particular day and it is to end on this particular day, whether that's a year from now or 6 months from now or whatever the amount of time is, that's a fixed term lease. And landlords can't raise the rent in the midst of that fixed term lease. They've agreed that you are going to rent this property, these premises for that period of time for that amount of money. There is another type of lease called a periodic lease, which is a lease that doesn't have a particular end date. And sometimes leases start out as fixed-term leases and then turn into periodic leases where there is no end term and you're just paying, for example, every month. That's the most common type, and that's called a monthly periodic lease. So if you were in a periodic tenancy, then the landlord can increase the rent, but they can only do so once per year. And so there has to be a year in between rent increases, and it has to be a year from the beginning of the tenancy as well. And if they're going to increase the rent, then they have to provide written notice of at least 3 tenancy months, I believe, before that rent increase is to take effect. And if they don't provide that notice, or if the notice is prior to a year, then any rent increase that they try to impose is not enforced. There is no upper amount that the landlord can increase the rent. As I said, in Alberta, there is no rent control. In theory, a landlord could raise the rent by 100% or more of the rent that the tenant is paying. Now, there is something in Alberta called economic evictions.
And I also have written an article about that process on our Law Now publication. So for folks that want to learn more about economic evictions, you could, of course, refer to those resources. And moving on here. So a landlord can install video surveillance in a building.
So again, the lawyerly answer is it depends. So in some areas, I think a landlord can justify installing video cameras, but it can't be too intrusive with respect to the privacy of tenants. So of course, a landlord could not install video surveillance within a tenant's private space, so within the premises. But in common areas, it's possible in some situations. There are rules that the landlord has to follow about who has access to that video. I think there is, again, a decision by the Office of the Information and Privacy Commissioner that basically there was a situation where a landlord was giving all of the tenants access to all of the surveillance. And I think the commissioner said, no, that's too intrusive because too many people have access to that particular surveillance. So again, the answer is it depends. Generally speaking, in common areas, it's probably okay. There may be some situations where it's not, like if it's targeted at a particular tenant and there's a camera just facing their door so that the landlord can, determine the comings and goings and who's coming and going of that particular tenant, then maybe that's not permitted. That's too intrusive. But if it's just sort of a passive surveillance system in the hallways for security purposes or at a front door of an apartment building, then that's probably in most cases okay.
Yeah, I remember a couple of years ago, we got this email from a member of the public mentioning that they really felt uncomfortable and uneasy because their landlord was actually installed a camera that kind of shot into their bedroom. So yeah, anyhow, if you ever feel that, you're in a situation maybe a little intrusive, raises some privacy issues while renting, and you feel like maybe you're being watched like this, or this, well then, really refer to the Office of the Information and Privacy Commissioner of Alberta, or OIPC's website. They have an excellent resource, Landlords and Tenants Guidance on PIPA. Okay, so moving on here, Tim. So next myth, a tenant can only face an eviction when they do not pay their rent or miss rent.
So that is a myth. Certainly, if you don't pay your rent or you miss your rent, then that is defined in the Act as a substantial breach of the tenancy agreement, and you could be subject, not necessarily would be, but could be subject to an eviction in that case. But there are other reasons why a tenant can be evicted as well. For example, if a tenant assaults or threatens assault on the landlord or another tenant, that's a situation where a tenant can be evicted in actually very short order, like within 24 to 48 hours sometimes. That's a situation where an eviction can take place. And sometimes there can just be a series of breaches that the cumulative effect of which is substantial. I think that's generally how the Act defines it. So that just means if there's a whole bunch of breaches of the Act or the lease, and basically it's enough that a decision maker is saying, you know what, this is a substantial breach. They all add up to a substantial breach. Then an eviction can take place. So one example of this might be if there's persistent late payment of rent. So rent is always paid, but it's paid, 10 days late or 12 days late or 5 days late, and that is a pattern that's consistent. That can sometimes be enough to be a substantial breach that can lead to an eviction in some cases.
Okay, thank you here. So, and then next one here. Animals are never allowed in rentals, especially if there is a quote unquote no animals or quote unquote no pets rule or bylaw in place.
Yeah, generally speaking, if there's a no animal clause in your lease, then you would not be allowed to have animals in your place, although there are some exceptions that relate to human rights legislation and discrimination. For example, if it's a service animal or something like that. And I think, Judy, you have some more information or visuals to provide on that particular point.
Yes, for sure. So we love explaining things with visuals here. So to help us explain pets and support animals in rentals, Jessica, let's pull up our next exhibit here. Welcome everyone to the universe of Hello Kitty and Friends, a page straight from my own digital Dear Diary. And this is a special edition image here. You won't see this in a CPLEA tip sheet because we would run into some trademark issues with Sanrio. But whether you can have pets or companion animals in a rental really depends, right? So check your lease and any condo bylaws, as Tim has already mentioned. So you have to take a look at your lease. Monkeys and raccoons in one quadrant, but never say never, but it may be tougher for landlords to accommodate these animals for practical reasons in real life. So for more information, you could, of course, go to CPLEA's Law and Housing Law column. I do have a recent article on emotional support animals for folks to refer to. And also, we do have many resources on pet and emotional support animals that you could refer to on our landlord and tenant website. So, moving on here, let's talk about myths with tenancy disputes. So, if a tenant is having a problem with their landlord, um, sometimes folks may feel that they can't do anything about it. So, what do you think about that, Tim?
Well, there are a number of things that tenants, a really important piece if you are wanting to take any other steps, such as starting a claim, which I'll get into in a minute, that you have shown that there has been some communication with respect to the issue. And to the extent possible, make that communication in writing or by email or some verifiable means. So even if you have a verbal conversation with a landlord, it's really recommended that you follow it up with an email saying, hey, just following up on the conversation that we had today. Here's what I said, here's what you said. And, at least then you have some sort of record that you can point to later if you need to. So if that communication, though, is not resolving the issue, then you can take other steps. And I referred to something earlier in the discussion called rent abatement. So what that is a type of claim that a tenant can make to get a return of the rent that they've already paid because the landlord isn't meeting their end of the bargain. So if they're not providing the amenities or service or things that the landlords are required to provide, then a tenant can make an application, say, to the court or the RTDRS to say that I want some of my rent back because I wasn't getting what I bargained for. So that's another step that a tenant can take. Generally speaking, I won't say it's easy to take that step, But if you make an application to the RTDRS, that is a tribunal that's designed for people to attend and run a hearing on their own without representation by a lawyer. The forms are submitted online, and there are ways that you can bring a rent abatement application. The other thing that a tenant can do is if the landlord is not meeting their basic obligations and meeting the minimum housing standards. So there are minimum housing standards that landlords are required to meet in order to rent out living spaces. If the landlord isn't meeting those, then a tenant can contact Alberta Health Services, and they will sometimes send out inspectors who can look at the place. And if they agree that there are minimum housing violations, they can make an order requiring the landlord to make fixes and provide a timeline as well for those repairs to be made. So there are a number of steps that a tenant can take to address those kind of situations.
Well, from rising from this too, Tim, I do have a few follow-up questions. So one thing that we hear about is situations where landlords might not be meeting their obligations, perhaps are neglecting repairs. That's a common thing we hear about too. If there are any problems in that type of space, and there's a dispute, and some people think that some tenants think that they have the right to withhold rent. So can they do that?
No. I've mentioned rent abatement, and I'm careful to say that it's an abatement of rent already paid. So there is an obligation to pay rent. And if a tenant does not pay rent, that is by definition a substantial breach. And so that certainly puts the tenant at risk of being evicted for non-payment of rent. Now, that doesn't always happen, and sometimes there can be a hearing and the tenant can say, well, I didn't pay rent because of this, and they can establish that there is a sort of claim, rent abatement type claim. But it's risky because if you're not successful in that, then you are then still at risk of being evicted for non-payment of rent. So, I think in most circumstances, in almost all circumstances, a tenant should keep paying their rent. And if they think they have a claim against their landlord, then they can bring that claim separately.
Okay. All right then.
Sorry, I do want to, the one other thing just came to mind. So I talked about a rent abatement claim. There's another type of claim that a tenant can bring, and that is making a claim for incurring costs for performing the landlord's obligations. So for example, if there are repairs that are the landlord's responsibility to make, and the tenant has told the landlord about that, and the landlord is not taking any steps to make those repairs, sometimes it's just easier for the tenant to go ahead and make those repairs themselves. And so they incur costs, like they might buy materials, they might have their own time that they put into making those repairs. So sometimes those costs are recoverable as well against a landlord.
Okay, all right. And you've already mentioned here about RTDRS being a dispute resolution method for tenancy issues, more specifically under the RTA. But is there anything else that tenants can do?
So yeah, RTDRS is sort of the primary place that you would bring an application. You can also make an application to the court. In most cases, the court hearing and process is more complicated than the RTDRS and probably will take a little bit more time. But in some cases, there may be good reason to bring a court application. Should probably be getting legal advice in that situation. And then I also mentioned that you can contact Alberta Health Services. So that's another venue that you can use, or process that you can use in order to get a response from the landlord.
Yeah, and that's for minimum housing health.
Correct.
Yeah, the standards. Yeah. Okay. All right. Okay, so moving on here, I do have to admit, Tim, that tenancy law can feel a little bit of like a polarizing space, especially as portrayed in the media and also over social media. And one of the things we hear about, depending on which perspective you're coming from, is that all landlords are the same. They are all shady. So, thoughts on that?
Um, yeah, I mean, I come to this issue as well with a bit of a bias because most of my work is done for tenants, and on behalf of tenants. But uh, you know, it, it's not true that all landlords are shady. I think there are some that do have some work, some landlords that do have some work to do to learn about what the law is and what their responsibilities are. But there are lots of landlords, that are good. And going back to our last question about what are steps that tenants can take, one that I didn't mention, but I think is really important, and is to communicate. I think I mentioned it earlier, but um, and if you have a good landlord, then you should be able to communicate these issues and hopefully come to some sort of resolution, between the two of you, because it is really a lot of time and effort and sometimes money to bring claims. And it's usually much better for both the landlord and the tenant to be able to talk about the issue and come to some resolution. So there are lots of landlords out there that are agreeable to listening to their tenants and addressing issues. I just don't see them because it doesn't, people come to me when there are problems, when that process breaks down. Yeah.
Sure. And maybe I'll provide also a little bit of a alternative perspective here, just because we've actually worked with some real estate industry groups in developing our own resources here at CPLEA and also have done some training. So I'll weigh in a bit. I do want to acknowledge here that people have had a range of experiences with less than ideal landlords. We've heard it all in some ways. And to complicate things, I think there really is a gap in data, though, when it comes to statistics about landlords in Alberta, that can help us better understand some of these tenancy problems that are floating around. But based on the work we do, of course, I do agree with you, Tim, that we do find that landlords come in all forms. Our housing law resource users here at CPLEA span the entire gamut of the housing sector. So it includes tenants, landlords, housing and service providers, property managers, to even investors. So a little bit more of a bird's eye view. The fact is, there are many types of landlords or people who earn money from rental property. So Jessica, let's pull up an exhibit here of the different shades of landlords, hand illustrated by her. So on one end of a spectrum, just for all of you folks out there to help you understand, you often hear about the slum landlords in the media, right? So these are the types of landlords who make the news for running unsafe properties that look like neglected dumps. So that's kind of like those sensational headlines, of course. And as you move along the spectrum, you also hear about the shady ones, often amplified in social media echo chambers, who have questionable practices and also dealings with their tenants. Then moving along, there's also landlords that may be accidental landlords, right? Which is something you don't really hear about often at all. But these are people who can't sell a property they lived in, or maybe they inherited a property. So they may be a little overwhelmed and are just trying to get by with figuring out what to do as a landlord and learning as they go. And then there's what I like to refer to as the ghost landlords, where the landlord is an entity. So, for example, a corporation or a nonprofit organization, and you have property managers who step in and do the everyday duties of a landlord for them. And then, of course, you also have the what I like to think of the platinum standard landlords, and these are the folks you don't hear about in the news much at all, are the ones who go the extra mile in learning about how to be a good landlord and are actually recognized in the industry for the work that they do. And, they're upgrading their legal knowledge, sometimes with the ethos that with great power comes great responsibility. And they're unafraid to learn about difficult topics such as dealing with trauma, domestic violence, emergencies, and deaths on properties. And in fact, CPLEA's Domestic Violence for Landlords Toolkit project was an initiative that brought these types of good, committed landlords together to create a practical, accessible resource for everyone to use. But beyond this, I do want to highlight, there's another development here that you may have heard of REITs. So these are real estate investment trusts. Think of them as the invisible hand landlord that's much more systemically entrenched and also growing in the housing sector right now. And these are companies that own and operate income producing real estate or related assets with hundreds, thousands of rental properties as part of that asset mix. And then, of course, with that, you have the REIT investors who are actually invisible shareholders in the whole system. And these investors usually acquire these REITs on stock exchanges to diversify their portfolios and also have a stream of passive income. And outside of this entire spectrum, you have folks living in cooperative housing entities that don't have landlords or tenants technically. They are members, they are member governed and run. So really long story short, there are all types of landlords with different behaviors and motivations, and folks that also don't fit in neatly into this what seems to be kind of this binary looking landlord tenant system. So I do like to thank you, Jessica, for being my invisible hand today, for making this image a reality. So I see here we do have some time to cover a couple more myths, and then we could jump right into some Q&A with the audience. But Tim, what do you think about tenants? Can they refuse landlords entry into their units?
So the answer is yes, in some circumstances. So in order to enter a tenant's unit, a landlord either needs consent from that tenant, or they need to have provided notice before the entry of at least 24 hours and in writing. And it has to be for one of the reasons that are set out in the Act. And so I'd refer you to Section 23 of the Residential Tenancies Act, which sets out the reasons. And so those include emergency repairs. So if there's like a pipe that's broken and water's leaking everywhere, then a landlord can enter in order to fix that. To control pests, if the tenant is leaving and the landlord is going to be showing the premises to prospective tenants, that's another reason where a landlord can have entry after notice. And again, in those circumstances, though, the notice has to be provided at least 24 hours before. There are some other rules. It has to be, between the hours of, I think, 8 a.m. and 8 p.m. It can't be on a holiday. And I think generally speaking, Sundays are considered a holiday. But if the religious day of worship of the particular tenant is some day other than a Sunday, and that tenant has provided notice of that, then the landlord can enter on the Sunday, but not on the other religious day of worship that the notice has been provided for. So there are some rules around when and how much notice has to be provided. And if that notice is given and it's for one of the reasons that is allowed, then a landlord can enter into a unit even without consent. But the landlord can always knock on the door and say, "Hey, can I come in?" And if the tenant agrees, then they have consent to do that.
Okay, here. All right. So moving on to the next myth before we jump into Q&A here. I find that there's often confusion about security deposits. So in what circumstances can landlords keep a tenant's security deposit?
So a landlord can keep all or parts of a security deposit where there's unpaid rent that's owing. So if there's arrears of rent, there can be a deduction from the security deposit for that. And where there is damage that goes beyond normal wear and tear. So there's probably lots of gray area in that phrase, where normal wear and tear. But you can sort of think of it as, if I have some carpet that has been walked on for 10 years, then there's probably going to be some wear in the high traffic areas. And so that's normal wear and tear. And so, the landlord can't charge the tenant on when they move out for replacing all of the carpets, because the carpets probably need replacing anyway, because of that normal wear and tear. On the other hand, if a tenant has, burned a hole in the carpet, then that likely would constitute damage that there can be a deduction. Now, the landlord's not supposed to be able to deduct for all of the cost of brand new carpet in the entire premises, but they can deduct for some of the cost of either repairing or some of the replacement, if there is a replacement for that carpet.
All right. Well, thanks for that, Tim. We do have a couple minutes here now that we're in the last quarter of our webinar today. So what myths do you want Tim to bust? Are there any remaining questions that some of you may have in the audience? Any burning questions that maybe we haven't already answered today? Anything that you would like us to follow up with? I do encourage you to type out any questions that you have in the chat here.
So the
Oh,
question is, do you happen to have a resource regarding the limitation of what a tenant and landlord can or cannot do when it comes to lease and renting. And I think I
Oh, I
usually
see.
refer
Okay.
that question just to go see the CPLEA website because there's lots of great resources
Y-
there.
Yeah, there's lots of good resources here. So thanks, Tim. I see the Q&A box now. So lots of information on our landlords and tenant website, of course. For a starter pack, we also do have a renting 101 resource as well that you could refer to for just basic information about what landlords can and cannot do, and also tenants can and cannot do when it comes to the renting process. And that's all written in basic plain language as well. So I would highly recommend that you refer to that. Um, let's see here. I'm just reading from the top here, Tim.
Yeah.
This question would be for you. So, can a landlord charge for carpet damage if they are going to replace with hardwood?
So yes and no. So I think if there is damage, then I think a landlord could make a deduction, and if they can show that it was actively damaged by the tenant, they may very well be able to do that. If the tenant, though, can show that, you know what, they were going to rip out the carpet anyway, so really it doesn't matter. It's possible that a decision maker at the end would say, "Nah, I'm not gonna allow the landlord to get any damage from that because they were going to do that replacement otherwise." So again, the answer is it depends. But even if there was damage charged, it can only be for repair of the damage, right? So if it would just like if it was a small little piece of the carpet and it came to repair it, that's all the landlord gets. They don't get the cost of, putting hardwood in because that's an upgrade. They don't get the windfall for doing that.
Okay, so I hope that is a satisfactory answer here. So we'll move on to the next one. What changes are coming to rental law in the near future?
Um, that's a really good question. I don't really have a good answer to that. There's an organization called the Alberta Law Reform Institute that's been looking at residential tenancies, and they've come up with some recommendations. So I would maybe look to them. One of their recommendations that just came out had to do with something called landlords distress, which is a very little used remedy by landlords. And their recommendation is that that be abolished in Alberta. But that's pretty technical. We probably don't need to get into it here. Um, I mean, that's all I can think of. Judy, are you aware of any other changes that might be coming down the pipe?
Well, I agree with you on that point. So our friends over at the Alberta Law Reform Institute are looking into this right now, and we'll throw that link up too as well in chat for folks who want to do a little bit more of a deep dive. So next one here, can a landlord give a blanket notice to a tenant to enter the premises if they are trying to re-rent the premise?
So this is a question I've seen before. My answer to this is no. So I think what the question is referring to is a blanket notice where the landlord is saying, "I'm going to enter your premises on Monday, Tuesday, Wednesday, Thursday, Friday between the hours of 8 a.m. and 8 p.m." And then tries to rely on that as sufficient notice to come in at any of those times. My answer to that is no, that doesn't comply with the act about providing a specific period of time. There is no specific period of time that's like required in the act. What I sometimes tell people about what's reasonable is, think of it in terms of like when the cable person is going to come to your house. Maybe that's not the best example, but they usually give about a 4 hour window. I think that would sort of be the upper end of what would be reasonable in terms of notice is, something like that. It's preferably would be even more specific than that. I mean, really, the purpose of notice is to give the tenant notice so that they can arrange their life for this possible entry, right? So maybe they don't want to be there when the landlord comes in. Maybe they do, but they want to make sure that all of their family members are fully clothed and not taking a bath or, whatever during that. And I've heard stories of that where, landlords have entered when, a tenant has been in the shower. So like, that's the purpose of notice. So I think a blanket notice is not sufficient, and would not comply with the act. And I think there is some RTDRS decisions that agree with that position as well.
Okay, all right here. Paying for parking and your landlord does not have property signage up and other people within the area, not just the apartment building, continually park in your spot. What do you do about that? Is that something that you could claim for a rent abatement?
Yeah, I think so. I mean, if you are, as part of your lease agreement, parking is included, then if the landlord is not ensuring that parking is included, then I think you're not getting what you paid for, and I think you can make a rent abatement claim in those circumstances.
Okay, all right here. Any burning questions for Tim? If not, then I think, Tim, we could quickly wrap up here and also I'll do some closing remarks just for everyone to know where to get further information. So,
Sorry,
oh,
there was one more
is there one
question
more?
that just said, so to be clear, there is no 24-hour
Okay.
notice requirement for entry. So there is a 24-hour notice requirement for the landlord to enter without consent. That's the written notice that I was talking about. So I'm not sure exactly what the question is referring to, but Section 23 does require notice of at least 24 hours before the entry. So maybe that's the confusion. But 24-hour notice doesn't mean that there's a 24-hour window where the landlord can come in. I think it has to be narrower than that. The 24-hour notice is before the entry. It has to be, the written notice has to be at least 24 hours before the entry actually occurs.
Okay, all right. Thanks for catching that, Tim. So, just we're running out of time here as we get closer to 1 p.m. and I'll just do a quick wrap up and direct folks to more information and resources. So we do find that the root of many problems is a lack of information or knowledge about the law itself or where to go for more help. So I, of course, encourage all of you to go to our landlord and tenant website and also our related housing law resources to learn more. Just as a little bit of a disclaimer here, we're not the RTA or the law. We can't change the law, but we do try to explain law in an approachable, people-centered way and also connect folks with legal resources and help. So if you're looking for legal information and help, we do want to let you know that you are not alone. There is a whole ecosystem that you can refer to. So if you need help with legal research, you can go to our friends at the Alberta Law Libraries. For legal help for tenants. Of course, we have our friends over at ECLC and also the ATLAC program. There are also other places across Alberta for legal help if you're not in Edmonton. So our friends at various community legal clinics, CLG, Grand Prairie, Medicine Hat, Lethbridge, Red Deer, also duty counsel at the courts, student legal clinics at the University of Alberta and also the University of Calgary. And if you need more information dealing with a particular issue while you're renting, like privacy, human rights, minimum housing and health standards, or want to learn more about RTDRS processes, there are also many government-run services out there. And a special shout out to our friends over at Service Alberta and Red Tape Reduction, who also have a lot of resources and their consumer contact center available for RTA matters. And we did have an earlier question about what might be coming up with looking at RTA changes. So if you're interested in doing a deep dive into those problems under the RTA and RTA law reform efforts, well, our friends over at the Alberta Law Reform Institute are doing important work in this area right now. So that's to say, please stay in touch with CPLEA. You could visit our website, subscribe to our monthly e-newsletter at www.cplea.ca. You could also follow us on social media. We're on Facebook, Instagram, and X. And I'd like to say, please join us for our next webinar. That's the last one of this webinar season. We'll be covering money matters, busting legal myths about personal credit, debts, and more. And we'll have money mentors join us for that webinar on Wednesday, April 22nd. At noon hour. And last but not least, really, I would like to thank you, Tim. We would like to thank you for sharing with us your expertise today. And of course, thank you to all of you in the audience for joining us today. And as Hello Kitty would say, take care and see you soon, my friends.
Thanks, Judy.
Thanks, Tim.